My name is Jay Chauhan. I'm a lawyer in Richmond Hill for the last 40 years. And today's topic is the question of preparing a will. So what questions would arise in the mind of a person when they want to prepare a will? So to discuss the topic with me today is Anna Tajadot, who is also a lawyer, and we'll have a discussion on the question, but Anna will frame the questions and I will attempt to answer them, and to you, which is based on what a typical client that you and I have to face would be asking us. So based on my experience, I will address those questions. So I want to hear the questions from you as to what are the key issues.
Okay, sure. So I think one of the first questions is what questions should be considered when you are preparing a will?
Well, the most important questions to be addressed, Anna, is the question of who your executor would be. That means a person who will administer your will and manage the estate when a person dies. The next most important question is a question of the beneficiary, because these are the people that the client wants to give the benefit to, and usually the provision is that you give everything to your spouse, and if the spouse is not alive, to the children. So that is the normal. But there are many variations or specific gifts, for example, that you might want to give to a beneficiary. You want to name my diamond ring to my whatever, my son or daughter or whatever. And then of course you want to measure the relationship that you have with the spouse and the children to make sure that you observe those relationships, including the provision of the law that says that if there is it used to be a separate statute called the Dependents Relief Act, and now is a part of the statute itself for the wills, which essentially says that if there is a person that depends on you that has to be looked after, then you must make a provision for that person in your will, and if you fail to do that, then in that event the will can be set aside to make a provision for the dependent person. So these are the issues that you have to think about when preparing a will.
Okay. So do you need a lawyer to prepare a will?
This is a very good question. Maybe you and I as lawyers, we want the clients, we want to be able to make the money as lawyers, but I think I want to try to be objective in answering that question. You see what happens, you go to a stationer's shop and say, I want to prepare a will, let me just pick up a package which contains a printed form saying, I appoint so-and-so as my executor. So the printed portion says, I appoint, then there is a blank, and many people might fill it out by the wording to say, my son, my wife, for example. When you do that kind of a will, then the question arises, perhaps in the court, whether it is a properly a holograph will, which can be handwritten and still be binding, or is it printed, properly prepared, like a normal will, and as a whole to be read. And it creates a dilemma in the mind of the court as to whether only this case actually happened in Alberta, and I think that as a result, the court couldn't make up a decision which portion of the will is binding, which is not binding, and therefore my general feeling is that when you consider the decisions to be made, the low cost that most lawyers will charge for a will in the range of $300 to $500 for the two wills, the cost is very small when you deal with the question of your entire estate and critical decisions that you want to make, that in my opinion, the cost of a lawyer is very justified. So in broader terms, it is helpful to have a lawyer when you prepare a will, because not only do you want to consider these issues as important to make decisions with an objective party, but you also want the will to be signed properly, because the requirements of a properly signed will requires two persons to be signing at the same time who are independent of family members, because a family member who signs as a beneficiary loses the right to have a beneficial interest in the event that that person became a witness.
Okay. So what should I do if there is spousal conflict?
Well, in my practice, I have gone through a few situations when there's a conflict. See, a properly prepared will should contain a clause to say that the spouse gets the benefit if the spouse survives in a common disaster like an accident for 30 days' time. Now, this kind of a situation ensures that you have the interest of the spouse maintained, not only because they may be beneficiaries, but because you might have common beneficiaries if both of them have died. So in that event, you have to consider who the ultimate beneficiaries are. I just finished a will recently in which there was a second marriage, and where the question was what portion of the estate would go from both of them, because the estate is common for the two of them. And should it go to the children of the first marriage or to the common child of the two persons? So those decisions have to be made, and therefore if there's a conflict, then I think it is important to try to have a different lawyer.
Okay. All right. So how is a will administered?
Well, once a person dies, the will becomes technically effective, even before you issue what used to be called probate. And now the procedure in simplified language is called appointment of a estate trustee. So when you go through that procedure, there is in a probate or appointment of a trustee who is the executor, is technically appointed by the court with the court seal and is authorized to act on behalf of the deceased. So the deceased who could not do anything to carry out his mandate is then dictated through the will for the administrator or executor to carry out with the support of the court, which then watches through the appointment process, the whole distribution, and is concluded by an accounting arrangement in which you prepare a whole list of accounts to say, here is the money comes in from the estate, from the bank accounts, and other sources, real property, shares, etc., put into one account, distributed, accounted for, legal fees paid, and then you conclude the estate with a release or approval by the court, what is called an accounting, with the judge. So that's the process of administration.
Okay. So what happens if I don't have a will?
This question goes to the mind of many people, and I think most people, in my experience, don't want to talk about the subject or think about it, and therefore people very often try to find a resolution which is either not there, and from my reading of the statistics, a very small percentage of the population actually thinks about the will and carries it out. And therefore, if you do not have a will, it's important to understand that the beneficiaries without a will are then designated through the so-called intestacy provisions of the Succession Law Act, which then sets out mechanically what will happen to the person's estate. For example, if the person has left a spouse and children, the spouse will get a certain amount of money. I think the law used to be $75,000, and if there's one child, then the child and the spouse share that rest of the estate equally. If there are more children, then the distribution changes again in favor of the children, so that more people are sharing the same estate. In any event, for different situations, you would have to look up the law to determine who the beneficiaries would be in a situation where the no will has been prepared. And therefore, you have to first appoint an executor, you have to go through the court, and then you have to make a distribution based on the mechanical rules set out in the intestacy law that gives the benefit of the estate to those specific persons named in the statute. And therefore, you miss out on giving it. Usually what a person wants to do is to give the benefit to the spouse, which is not happening as a result of the fact that the will was not prepared. So I think that some people think that the government takes the property, that the government does not. I think what happens is that, in fact, if there is a child, the trustee, the public trustee might want to protect the interest of a child, to protect his interest or child's interest as a trustee. And only that share under intestacy would be controlled by the trustee until the age 18. But in essence, it is the initiative of the beneficiary that he has to take to bring it to court and make a distribution pursuant to the law. So these are the issues that you have to think about if you do not prepare a will.
Okay, that makes sense. Thank you very much.
It was a pleasure talking to you, Anna, and I
Same.
hope that information was useful to you. If you like to watch these programs, these are on YouTube or my website, www.jchohan.ca, under resources and videos. Thank you.